I call the Parliamentary Secretary to the Prime Minister.
Thank you, Mr Deputy Speaker. In fact, this is my first speech from the dispatch box, and I wouldn't think that there is any more important subject to speak on. And, Mr Deputy Speaker, before politics I was a Crown Prosecutor, and I prosecuted a very large number of matters at trial and sentenced a very large number of matters that involve sexual offences and offences of extreme violence against women that would fall into what is known generally as a broad category of domestic violence offences. And there are a small number of matters that I remember distinctly and that still from time to time invade my thoughts. One particularly involved a young Indigenous woman in Derby in the north of WA. And there's nothing to be gained particularly by relaying the facts of the matter other than to say it was a very serious matter. Because of the remoteness in Derby, my efforts to proof that key witness and the victim had proved completely fruitless, and I arrived the day before the trial. I sat in a very hot room in the courthouse in Derby. I simply could not convince this young woman to take her allegations to trial. And of course, the allegations thereby were never tested or proved, and it could not have been said at law that an offence was committed. I felt certain that the trial should have proceeded. As a citizen, I felt that the young woman should go to court, speak the truth and put the alleged assailant to the test before the jury, but as an officer of the court, my efforts to persuade her had to require a level of dispassion that I felt, and now in retrospect think, was completely mismatching the moral reality of the circumstances. This young lady had no mother there, no sister, no friend, no one who would give her any comfort or support and give her the massive courage that she needed to get into that box. And the outcome is one that I feel in my deep conscience was completely and utterly unjust, although procedurally in every legal sense fair. And nothing could have been done at that particular point, I think now in recollection, because at the point that I entered that causal chain of misery that had led that young woman into that courtroom door, it was far too late. After trials, I always had a sort of pervasive, sombre mood, but I remember driving in the long drive back to Broome from Derby just being gripped by sheer despondency. I had I must say in retrospect, not very constructive loathing of the alleged perpetrator, and that slipped very easily into this complete sense of despair that the scene I'd left was nothing but a wilderness beyond the effect of human improvement. And I think it was completely wrong to feel that way. Things can definitely be done. Human lives can be improved. There can be retreat from the sort of violence that we see against women all around us and on our doorsteps as well as courtroom doorsteps. And even if that retreat from violence is incremental and improvements are hard fought for, and even if some of them can be overturned at times and reversed, that effort is always worthwhile. But I would say to the Leader of the Opposition and to my friends on the Opposition and on my own side of this parliament that the key is to enter that causal chain as early as you possibly can in terms of public policy and do so in a way that is eminently practical and measurable. And I tried to do that as a State Attorney-General in a way that I thought was most immediate and most important. And if this is a crisis, whether there is a summit or whether this conversation continues at COAG, I would put to you all present that if it's a crisis and we want to do one thing immediately to make things better, we must ensure that violence restraining orders are worth the paper they are written on. As a State Attorney-General, I changed the law and I was persuaded out of allowing for mandatory imprisonment of those who breached restraining orders, and I now regret it. In Western Australia, and this plays out in every state and territory in the Commonwealth, at the time that I was Attorney-General, you could have breached a violence restraining order against your partner 4 or more times and only have a 25% chance of going to imprisonment. My government changed the law in Western Australia, just short of mandatory imprisonment, with the strongest possible legal presumption for imprisonment if you're a 3-strike breacher of a violence restraining order against your partner, and that figure of 25% increased to 30%. And that is, on any assessment, I would have to say, a colossal failure of response. I don't entirely blame the judiciary. It is a very difficult thing to show mercy on an individual basis and then have to face the statistical fact that that mercy causes misery on a basis at large. But I would say that in a country where an Aboriginal woman is 3 to 4 times more likely to be a victim of a sexual assault, where an Aboriginal woman is 40 to 40 times more likely to be hospitalised after an assault, where 50 to 60% of Aboriginal spousal assaults involve a weapon, that we must do something, that it is a crisis, and if I could point to one thing for all of the members of this House to think about, it would be making violence restraining orders work.